Are children capable of evil? Well, that's a matter the courts have had to consider over the years. So what I'd like to talk about is something called Doli Incapax. And what's brought this on? It's to do with the Southport defendant, because people have pointed out and said he's avoided a whole life order merely because, of 9 days. Had he have committed those offences 9 days later, he could have been awarded a whole life order, and the judge indicated he would have awarded a whole life order. So it's this idea that there's a bright line where up until midnight on that day, this is what can happen, but then as soon as 1 minute later, the paradigm completely changes. And people say, well, shouldn't there be perhaps some sort of a spectrum, on that? And it's interesting because we sort of did used to have that. Let me explain a little bit. I mean, I don't want to get too much into that specific case. One thing I would say about the whole life order thing, I know people are saying, you should have got a whole life order. I mean, to come back to, and just, on the back of my previous video, the 52 years is the minimum time he can serve before he can even apply for parole. And as I've said, with whole life orders, although it's meant to be whole, you are still allowed to apply for parole. It's just, there's no time limit on it. And interestingly, in Myra Hindley's appeal, because Myra Hindley was originally sentenced to 25 years in prison for her role in the Moore's M words. But over time, various Home Secretaries put that tariff up. I mean, it went up to 30 years, 40 years. But then actually, somebody put it up to a whole life order. But interestingly, they didn't tell her. And she only found out 4 years later. In a House of Lords, in a case that went all the way to the House of Lords. Now, what was interesting there is the House of Lords says, look, you have to tell prisoners. I mean, it's all slightly changed now because politicians have less role. It used to be it was up to the Home Secretary to adjust the tariff, but now they said, no, that makes things too political, we'll leave it to the judiciary. But interestingly, in that House of Lords case, the House of Lords said somebody on a whole life tariff, perhaps it wouldn't be unreasonable for them to apply for parole after 25 years, with the caveat that they would really have to show that they had changed. I mean, Myra Hindley did it on the sort of I'm born again thing, although she later admitted and said that was literally just for the parole board. It was all nonsense. But, so like I say, a whole life order, ironically, wouldn't necessarily stop somebody being released. But when it comes to children, there's an irrebuttable presumption in England and Wales that a child under the age of 10 cannot commit a crime. So what's an irrebuttable presumption? Well, as the name suggests, it is a starting point. We will presume that this child cannot commit a crime. They don't know right from wrong. They just don't have the capacity or the competence. And it's irrebuttable. You can't say, well, actually, this child, he might only be 9, but look at this. We've got all his journals, we've got his planning, we've got his internet searches. Clearly, this is somebody who does know right from wrong and does know what a crime is. It's like, well, sorry, it doesn't matter. The age of criminal responsibility in England and Wales is 10 years old. But it used to be that between the ages of 10 and 14, there was a rebuttable presumption that they were incapable of committing a crime. So again, the starting point was this child under the age of 14 cannot commit a crime. However, it was a rebuttable presumption. So that said, the prosecution can seek to prove that actually, no, they do know right from wrong. And it's, more than just mischievous stuff, that they know it's seriously wrong. I mean, it's very similar in some of the tests to like insanity and diminished responsibility. So there is a bit of a crossover, but it's all the same idea, isn't it? That we should only punish people for culpability. We should only punish people for actual wrongdoing when they realise it's wrong. Because, what's the point of punishing somebody who doesn't know that they did something wrong? Although one of the challenges to Doli Incapax was, they said it just rewarded sort of bad parenting and, thick kids. It's like, they've got no idea they've been brought up. So, kids who are just feral couldn't be prosecuted. It's because they'd never had any sort of like, moral teaching or anything like that. So, in 1998, the Children and Young Persons Act of 1933 was amended to introduce Section 50, which actually abolished Doli Incapax and the rebuttable presumption. So now any child over the age of 10 years old is deemed to know what they're doing and is capable of committing a criminal offence. So it's very interesting, like I say. So now again, it is just a bright line. Once you're over 10, you can be tried, in the youth court or tried as an adult for serious offences. You remember all the Bulger case where those children were effectively tried as adults. I mean, we do try and modify the case a little bit, like, people might not necessarily wear the wigs and the gowns. You don't want to be too intimidating. And that's not a soft touch on the people. It's, going soft on them. If they're capable of these acts, then they should face the consequences. But at the end of the day, look, you want a fair trial and you want the best evidence to come out, including from the defendants. And if they just don't have a clue what's going on. Although what's quite interesting is, we are told in lots of cases involving children that you should check, don't robe up, wear your fluffy jumpers. But now the rule is the judge asks the child, especially like family stuff, so, what do you want people to wear? And it's quite interesting how many children come back and go, no, I want this taken seriously. I want this to be a proper case. So yeah, get all your fancy dress on. I want to be taken seriously. This is important to me, and I don't need all this fluffy stuff. I want it doing, I want it doing properly. But this is how we deal with it now. Like I say, there is no spectrum. It can be reflected in sentencing. So obviously, had that Southport guy been, 11 or 13 or something like that, that might have been reflected in the sentence. So the mere fact that he missed the whole life tariff, I mean, the judge has pretty much sentenced and gone, this is a sentence that realistically is, going to be the equivalent of a whole life tariff there. But we have something similar as well with this bright line thing called Gillick competence when it comes to children. Because it's all about, children mature at different rates and, just having a blanket arbitrary line. I mean, sometimes you have to do that. It's like, we have the age of consent. It's set at 16 years old. And it's like, that is to protect children. So, yes, it is a bit of an arbitrary line in the sand that literally people can sit there with their stopwatch being all creepy and going, ooh, nearly time. But, we just draw a line because we have to. And that's what it's put. And it's the same with, adulthood. Children are now adults. You become an adult at 18. You used to be 21. But, the law just states that this is, how we are to regard these things. But what's Gillick competence? Well, you may remember some time ago, obviously, like I said, the age of consent is 16. So, if children are engaging in activities before then, arguably at least one person is committing an offence. But doctors were prescribing contraception for under 16s because they said, look, they're doing it anyway. We may as well, sort of let them have the protection. So somebody called Victoria Gillick challenged that. She said, well, that's got to be unlawful because by definition, those doctors are aiding and abetting criminal activity. And this all went, all the way to, again, the House of Lords as was then. And they said, well, look, we appreciate what we're saying, but we're saying some children are mature enough to make their own decisions, but we accept it's on a case-by-case basis. And they said, obviously, if people who are nearly 16 are coming to doctors and the doctor assesses that they clearly know what they're doing, they might sort of tell them and say, look, I'm not really sure this is wise to be doing activities like this and here's all the risks, but if you are going to do it, okay, I will prescribe this. And they say that if the doctor says they're mature enough to do that, they can do it and they don't have to tell the parents. Similarly, it's like with medical treatment. Can children refuse medical treatment? Charles, a Jehovah's Witness, doesn't want a blood transfusion, which would kill them if they didn't have it. Well, they've sort of said, in the same way that an adult can refuse, if this child is mature enough and realises the consequences and has made a settled decision, maybe we should respect that. I mean, in practice, they do tend to sort of go, we'll force you to have the treatment. So yes, we appreciate you think it's a sin and all that sort of thing, but we force you. It's not your decision, so that's your sort of get-out clause for your conscience. But, like I say, that is the test. I mean, technically speaking, we call it Gillick competence. Lawyers tend to call it the Fraser test after one of the judges who sort of said, but he said a very simple test. He said, you just look at the facts and you go, is this child capable of making an informed decision about what they want to do? And it's a sliding scale. I mean, arguably, I've sort of said, Very unlikely that a child under 13 would be Gillick competent, but between 13 and 16, and 13, and 13 and 18, well, we'll just look at the actual facts, and it's a bit of a sliding scale. The older they are, the more likely they are to be in a position to decide that. I mean, like I said, and this all gets very interesting, because what happens is, and to go back to the Doli Incapax thing, what happens if you've got like a multi-hander, a joint enterprise, where people are of different ages? So what if, say, somebody commits an offence, a young person commits an offence, and they are aided and abetted by older people, but then as a matter of law, the court says, well, actually, they did not have the capacity to commit the offence. And this actually crops up. There was an R-word case. Now, this was in the old days of Doli Incapax, when it went up to 14. And the child who actually done it, did the act, was ruled to be Doli Incapax, incapable of evil, not realising for their own personal circumstances. They said this is a kid who just didn't realise what was going on because he'd been encouraged by these older kids. So he basically couldn't be proceeded with. I mean, you can still have a hearing in the same way that when you're looking at sort of mental health issues, somebody is not responsible by reason of insanity. You can still have a trial to say, did they actually commit the act? Then, they're not criminally liable for it, but we still need to establish in the first place, did they actually commit the act? And that was the same thing when it came to children. So I said, yeah, we've had a trial, we accept the child did the act, but they're not responsible. But what about the people who encouraged him? Well, they were convicted, they were acquitted initially. But then they said, well, hang on. I said, why have you quit? I said, well, you can't aid and be an accessory to a crime if we've just said there was no crime, because, the principal wasn't held to be criminally liable. But the court said, well, no, it's not quite like that, is it? Because the mere, a crime was being committed in the technical sense, somebody was doing wrong. So the mere fact that as a matter of law and a technicality, effectively, they're not guilty of the offence doesn't mean you're not guilty of aiding and abetting that offence. Because otherwise, for policy reasons, let's say you want to rob a bank, you just find a bunch of 13-year-olds, put masks on and give them shotguns, go in and rob the bank, and then it's like, well, they can't commit a crime, so the mere fact we encourage them and set them up to do it means we can't be prosecuted either. So that was the rationale behind that. But yeah, like I said, this idea of where you draw the line in the law, and this is why we do give courts discretion, even in cases like the whole life tariff. It's like, yes, this is, intended to keep you in there, but we still leave open the possibility for some discretion. We don't really like fettering people, because you never know. There's always one weird case that doesn't, we always say bad, hard cases make bad law, but there's always one weird case that doesn't quite fit. I mean, it's like possession of a firearm. Possession of a firearm in this country, there is a mandatory minimum sentence of 5 years. However, there is still unless there are exceptional circumstances. So unlike in the US, where they have mandatory minimum sentences that the judge just has to impose and has no wriggle room or discretion, over here we tend not to get into mandatory sentencing. There's always some wriggle room there. So it's even things like, the lower end of the spectrum, like driving bans. It's like, if you get 12 points or more, you must be banned for driving for 6 months. However, there's special reasons and exceptional hardship and all that sort of thing, that there may be circumstances where, well, yes, technically you've committed the offence, however, there are reasons for not imposing the usual penalty. So we always like to leave a little bit of judicial discretion there. But yeah, I hope that's answered the question, because like I say, I noticed a lot of you in the comments discussing this idea that it is really, really arbitrary and maybe it should be more of a sliding scale. So like I say, the law, in terms of crime, when we had Doli Incapax, it did have that sliding scale, that spectrum where you looked on a case-by-case basis, but that has now gone. I mean, that's not to say that a judge wouldn't take into account sort of relative maturity and things when it came to sentence, but yeah, the idea that you now have to show that children knew they were doing wrong has vanished. And similarly, like I say, with Gillick competence, again, you look on a case-by-case basis, because the argument is, yeah, well, look, we just need to be practical about such things, and just setting things written in stone you can never depart from quite often can lead to some perverse decisions on its own. But there you go. As always, hope you found that, moving across, vaguely interesting, vaguely informative, vaguely accurate. I am hoping to get out and do my video soon. It's actually marginally stopped raining, although every time I set off to go out, it does start raining. So if there's any farmers out there suffering from a drought, just want me to come and, for a nominal consideration, I will come and attempt to shoot a video in your field.